SJC-12795, Commonwealth v. Xavier E. Rodriguez.
And again, there's a bit of crack. We've had some crackling issues, so if everybody could be careful to make sure that their phone is mute or off of the speakerphone, if you could. And we'll turn first to Ms. Latour on behalf of the Commonwealth.
Thank you, Your Honors. Good afternoon. May it please the Court, Monica De La Torre on behalf of the Commonwealth. The single justice abuses discretion here in denying the Commonwealth's petition without reviewing the merits because the petition presented an exceptional circumstance involving a legally erroneous discovery order of confidential informant information that flies in the face of firmly established discovery law and that has systemic ramifications on cases involving search warrants and utilizing confidential informants. The petition circumstances are exceptional first because the Commonwealth petition sought relief from a legally erroneous discovery order to which the Commonwealth has no adequate remedy. The Commonwealth is now in the untenable position of determining whether to comply with the extensive baseless discovery order and expose confidential informant information. And secondly, the petition involves a systemic issue. The order in this case has already been replicated in a number of other cases, including with the same motion judge and other judges, where motions for confidential informant information are being allowed despite no showing of materiality to the defendant's defense. And this order will continue to have those ramifications. Under the defendant's paradigm and this erroneous order, the Commonwealth will have to provide this highly sensitive information in every case of a search warrant that has a confidential informant, regardless of whether the confidential informant information relates to defendant's charges. This will, in effect, eradicate the confidential informant privilege, would also defeat the well-established procedures under Ambrell and Franks, and will also eradicate the presumption of validity of the search warrant application. And these are the consequences of this order because the order had no legal basis. No legal precedent allows disclosure of confidential informant information without a showing by the defendant of materiality or relevance of disclosure to a trial defense. No legal precedent allows disclosure of confidential informant information in order for the defendant to investigate potential challenges to the validity of the search warrant application, which was the basis for the defendant's motion here. And no legal precedent allows discovery without a showing of relevancy, which is also not shown here as well. So as such, the denial of the Commonwealth petition and failure to correct the order will endanger the safety of confidential informants and have a chilling effect on investigations where confidential informants play a role. And with those systemic ramifications from the clearly erroneous order, the single justice erred in not correcting the lower court's order. And with that, I'm happy to answer any questions, Your Honors.
Okay, I'll turn to Justice Link.
Thank you. What are the criteria for an extraordinary situation, the compelling a single justice to grant substantive attention? What are the criteria for extraordinary?
Well, for an exceptional circumstance.
Yeah, that's exactly what I'm asking for. But that's extraordinary relief, isn't it?
Correct. So there are a number of things that are outlined in Fontana, including whether it's a systemic issue, whether it's a novel question of law, whether it will have a chilling effect on the Commonwealth case, whether it will have a crippling effect on that case and other cases as well. And I would suggest that all of those are present here.
And must they all be present in order for this to be an abuse of discretion on the part of the single justice?
No, they don't all have to be present. Those are all examples of exceptional circumstances.
Okay, thanks.
Mm-hmm.
Justice Gaziano.
Right. Let me ask you about the single justice's order, which kind of hedges bets a little bit, because I think the order says something like, well, you could comply unless complying would disclose the informant's identity. You could move for a protective order, or you could ask for reconsideration. And one of the issues that's identified is that your brief is much more fulsome in the description of the harm than the petition. So that wasn't before the single justice. So it may require you to come back to us, but isn't this something where it would not be an exceptional circumstance because you have the ability to look at what the disclosure would do and then to further appeal that?
Well, I suggest that we noted in our 211.3 the potential of this to have systemic ramifications, and since we filed the 211.3 in our brief and our reply brief, we have noted at least 4 different occasions where this type of motion has been allowed. I would note that for the single justice order suggesting a potential protected order or redaction of certain information does not address the systemic ramifications at issue.
But that wasn't in the systemic issue wasn't before the single justice, right? So what I'm suggesting is if you think it would disclose it, you could put that in your motion for reconsideration and put that in front of the single justice.
I'm sorry, I believe I understood the single justice order to be a motion for reconsideration in front of the trial judge.
It is, but what I'm saying is that the whole issue of systemic comes out post 211.3, correct?
Well, no, I mean, I think we noted within our 211.3
right.
That we had noted that this had been common within not only this court and other courts as well. And then since the 211.3, what we had predicted would occur has indeed happened in terms of having this systemic issue. And I think looking at this erroneous order itself shows that it has that potential for systemic ramifications.
But I guess there's an issue of finality here because Justice Lowy says something like, you can come back. You could disclose it unless you think disclosure is going to identify the informant. You could ask for a protective order to redact it, or you could move to reconsider. None of those things have happened yet, right?
That is correct, though I would note that the order in this case didn't allow for any other type of redaction other than the name of the confidential informant. And so the Commonwealth pursued the 211.3 here because of that systemic ramification and the fact that the amount of discovery here would identify the confidential informant. I would also note, I'm sorry.
And what I'm getting at is whether or not this is truly exceptional because the order by the single justice is so open-ended. That's I guess the main point I'm trying to ask you about.
I think that it's still an abuse of discretion in not addressing the clearly erroneous order here. The fact that it lacks legal basis is precisely the type of case which this court's extraordinary powers should be applied. I think the cases of DM and Jordan and Mello all acknowledge that when there is a clearly erroneous order like this, where there's piercing of the confidential informant privilege, it's an abuse of discretion to not review the merits of the case.
All right, thank you. That's all the questions I have. Justice Bud.
Good afternoon.
Good afternoon.
I'm trying to figure out, and maybe it's in the record, but I don't know, is there any place where you describe or explain why there isn't some information you can turn over without identifying the confidential informant?
That was not in the record. All we noted was that the petition does not circumvent the Commonwealth mandatory discovery obligations, but we noted in our opposition that the amount of discovery here would lead to the name of the confidential informant.
But doesn't the request specifically ask for information other than that which would identify the confidential informant?
It asks for information other than that would identify the confidential informant. It's clear from the discussion at the non-evidentiary hearing that is just referring to the name. But here, this is an extensive amount of discovery. It's looking for all of the records in the confidential informant file, and not just in this case, but in regard to other cases as well. And this would include search warrant numbers that could lead to docket locations, dates, persons in common, types of drugs or other items that were purchased, and what was discovered. So this would certainly identify the confidential informant.
And can you just explain why it is that you couldn't turn over what it is that you felt didn't identify the confidential informant and then make an argument for a protective order as Justice Lowy suggested in his denial?
Well, note that this is an extremely broad discovery order. It doesn't have any limiting dates, and it was all done without any showing by the defendant of why this would be useful to a defense. It was really brought just with the hope to find something useful. So this would have been a very large amount of discovery that the Commonwealth would have had to do that, again, would have identified the confidential informant.
And just so I understand, weren't there a couple of things about missing about the confidential informant, or about the or a little off that would sort of that gave rise to the discovery request in the first place?
Not that they were off of the confidential informant. The defendant had argued that there was no track record regarding the confidential informant, but not that there were discrepancies regarding the confidential informant. There was no factual assertions here that would have given reasonable doubt in terms of the veracity of the affiant.
Yeah, I thought there were questions about, the appearance of the defendant, whether he had braids. I thought there was a question about a question at least was raised, maybe not directly, but the fact that the controlled buys involved heroin, but they only found fentanyl as a result of the search warrant, things like that.
Yes, all three of those purported discrepancies within the search warrant were raised by the motion judge. She had said that she had taken issue with there being long braids, that there was a description of long braids, in terms of description of the confidential informant, and then in the driver's license photo that was used to identify the defendant. But then in fact, at the arrest, the booking photo, that he did not have braids and he did not have braids in front of Judge Grant. But the defendant could have brought that up and argued a misidentification defense. I think it's important to note here that the defendant here is charged with possession. He is not charged with any conduct relating to the controlled buys here.
No, I understand, but wouldn't it be prudent for a defense attorney to look into the whether or not the search warrant was issued with the proper probable cause? Isn't that something that...
I would agree with that, but the defendant never moved to suppress the search warrant here. It's sort of been a circumvent around that. The defendant wants to file a motion to suppress the search warrant based on discrepancies, and that's the defendant's prerogative, but that had never been filed here. Instead, the motion judge used those discrepancies to base her order for confidential informant information, and that is not a standard for confidential informant information disclosure.
Okay, thank you.
Justice Cipher.
Thank you. Is it my understanding that this motion, that no affidavit was filed by the defendant in support of this motion? Is that correct?
That is correct, Your Honor.
And so what, if any, effect would that have on a motion for rewards, promises, or inducements, as opposed to a search warrant motion, a motion to suppress?
Well, if this was I'm sorry, maybe I misunderstood your question, but in terms of it being a discovery motion as opposed to any other type of motion, there still needs to be an affidavit in terms of relevancy.
Okay, so you're saying that you still require an affidavit, even if it's not a motion to suppress?
Yeah, well, yes, if it was a motion to suppress pursuant to an AMREL type of motion, that would still also require an affidavit that asserts reasonable doubt in terms of what the statements of the affiant. And if this was considered some type of discretionary discovery motion, that would argue that because it's asking for confidential informant information that it's not, that also would require an affidavit to show relevancy here.
Now, assuming that this motion, this order stood, and the single justice's order stood, and you were put in the position of having to disclose something or take further action, has the time passed for the defendant to file a motion to suppress, or would they still be able to?
I don't see why the defendant wouldn't be able to file a motion to suppress here. No.
Okay. I have no further questions. Thank you.
Justice Kafker.
No questions.
I've got a few questions. This is Chief Justice Gantz. What do you say is the standard that we should apply as to when a justice abuses his or her discretion in deciding that a matter is not extraordinary?
Well, the standard is an abuse of discretion, and I would argue as here, where if no action is taken, it will significantly reduce the burden that the defendant has to show for this type of information, and also throws into the wind the legal precedent for discovery motions in general. I think this is the type of case that has that.
Well, the single justice didn't decide the matter. He simply said, I'm not going to decide the matter. So why does that establish a precedent that's problematic?
Well, I think under the case law, in particular with DM, Jordan, and Mello, if the single justice has declined to rectify the type of order that is in this case, that is an abuse of discretion that requires the court to step in.
Why?
Excuse me?
Why?
The order in this case, the order in this case didn't follow any of the requirements and any of the legal precedent that's necessary for confidential informant information, what's necessary for an AMRALS hearing, and what's necessary for a discovery motion. And I would suggest under those cases where they're discussing systemic ramifications from that and the need for the court to affirm legal precedent, I would suggest that needs to be done in terms of a superintendent's power.
So your view is that a single justice abuses his or her discretion when he or she decides this is not a matter that requires extraordinary review, and turns out that there's an error of law or a fact in the underlying matter. Are we supposed to hear every error that occurs in a trial and allow people to bring every error up to us? And it's been abuse of discretion for us not to resolve that issue. Is that the argument?
No, I think under the case law, when there's a legally erroneous order that has this type of ramification, it would be an abuse of discretion to not correct that order.
Right, but what if the single justice, as apparently it was not necessarily satisfied that it would reveal the identity of the informant?
Excuse me, I didn't quite hear you, Your Honor.
I get the impression that the single justice essentially said, I don't think it's extraordinary, in part because I think that it can be crafted so as not to reveal the identity of the informant. I view it simply as a matter of give them how much you paid an informant, and that might not reveal the identity of the informant, and if there is any risk of that the motion judge can craft something which will assure that it would not reveal the CI's identity.
Well, I think that doesn't address the ramifications at issue here. In terms of that wouldn't have been an adequate remedy here where this type of information would have led to the identification of a confidential informant.
But I mean, you say it does, but what the defendant's asking for essentially what promises did you give? How much money did you pay? Correct?
I'm sorry, Your Honor, I didn't quite hear the end of your question.
As I read it, as I understand it, and correct me, the defendant essentially says, tell me how much you paid the informant.
I would suggest the defendant has not articulated that basis and has not articulated why that information in this case is material or relevant to a defense where the defendant has been charged with possession.
Let's assume you're right, but why? What I'm perplexed as, why do you say that saying how much a CI was paid reveals the identity of the CI?
Because it would provide details enough to identify the confidential informant. That is why the amount of drugs that are purchased and the amount of money is not included within the search warrant. It would absolutely reach the identity of the confidential informant, but it wasn't just the amount of payment in this case. It was basically the entire confidential informant file, along with any other files that discuss this confidential informant. There's an extensive amount of discovery that was requested here.
Did the judge allow all of it? I thought the judge
allowed all except for there was a paragraph on the second page of the motion that was related to federal agencies. That was the only paragraph that she did not allow.
Okay, but the motion also said that there's no intent to identify the informant, and the single justice said frame it so that it doesn't pose that risk.
The motion didn't say that it did not identify. It didn't go quite as far as saying to not provide confidential informant information. It's just the identity of the informant in terms of the name. But I would suggest that what the single justice's order had does not address that issue in terms of the fact that it doesn't address that the clearly established case law is not being applied correctly.
Okay. I have no further questions. Are there any questions of any other justice?
I just have one more. I do have one more.
Yes, Justice Budd.
Where can I find? Can you point me to where in the initial petition the Commonwealth explained to the single justice the systemic issues that were at stake?
I believe we put it into. I believe it actually shows up. I apologize, and I'll have to double check. I believe it's in a footnote that describes it, and we describe that because there is a legally erroneous order that it would have these systemic ramifications, and we point the court as well to. We note that these motions are common in this court, and then also cited the court to DM as well.
And this was to the single justice in the initial petition.
That is correct.
Okay. Thank you, Mr. Latour. We'll turn to Mr. Smith.
Thank you, Your Honor. May it please the court, Joseph Smith on behalf of Mr. Rodriguez. Simply put, this case does not present extraordinary circumstances, and that's why the single justice here was well within his sound discretion in declining to exercise this court's power of general superintendents to become involved in this matter. Again, the circumstances here are not extraordinary. Nor did the motion judge abuse her discretion in allowing the defendant's motion for awards and promises in part. Here, there was no clear error in weighing the factors relevant to the decision in either court. Both decisions fell squarely within the range of reasonable alternatives available. First, with respect to the single justice's decision to deny the Commonwealth's petition, the judge, in his sound discretion, indicated that there were remedial alternatives that the Commonwealth could utilize if they believed that documents responsive to the order would identify the informant. These included a protective order, redaction of certain information that the Commonwealth felt might identify the confidential informant, or a motion for reconsideration. Another alternative, which isn't expressly referenced in Justice Lowy's order denying the Commonwealth's petition, would be for the Commonwealth to comply by giving the documents to the court and conducting an in-camera hearing. These were decisions that were reasonable, and they represented a fair weighing of the relevant factors, because the information would not tend to identify the confidential informant. I think that has to be stressed, that the Commonwealth hasn't adequately established that the disclosure of this information would in fact identify the confidential informant or have a tendency to identify the confidential informant. Therefore, it's not privileged, despite the Commonwealth's attempts to frame it as such. This is simply put, it's essentially a routine discovery order which does not identify anyone. And the issue is not adequately or sufficiently systemic or novel to warrant review. I would also argue, even to the extent that the court reaches the substantive merits of the Commonwealth's petition, this was information that was relevant and necessary, among other things, for the defendant to investigate possible Franks or AMREL challenges to the search warrant and its supporting affidavit. The motion judge, in this instance, had discretion to allow investigation. Again, this is not an allowance or an order for the Commonwealth to disclose the identity of the confidential informant. This is an order that allows for the disclosure of information that might be relevant to an investigation of potential substantive or dispositive pretrial motions. And so I would just argue that Mr. Rodriguez is entitled to prepare a defense, which includes, again, the preparation or investigation of substantive or dispositive motions, such as a Franks or AMREL challenge. Again, we're not deciding the substantive issues at this point. Whether after investigation Mr. Rodriguez would be entitled to a Franks or AMREL challenge. Those are motions that he could file in the future. He's not precluded from filing them by time standards or anything else at this point. And I would argue that discrepancies in the affidavit here may, among other things, create a foothold for example, a recklessness argument under the Franks decision. The documents that he requests may bolster this argument. And so I would ask that this court deny the Commonwealth's appeal, and with that, I would yield to any questions that the justices have.
Hey, Justice Link.
I'm all set. Thank you very much.
Justice Gaziano?
I have no questions.
Justice Budd?
No questions, thank you.
Justice Safer?
No questions. Thank you.
Justice Kafker?
How do you distinguish Commonwealth versus DM?
Your Honor, that's Commonwealth versus with DN, Your Honor?
DM. D as in dog, M as in Matthew.
Yes. Well, Your Honor, my recollection is that that case involved the actual disclosure of the identity of a confidential informant. That my recollection is the main distinguishing factor. That here we don't have any indication that the information that the Commonwealth would be obligated to disclose would in fact identify the confidential informant. I think it's important to note, based on the documents that are in the record, the documents that are requested from the confidential informant file are documents that are compiled pursuant to a Boston Police Department policy that's designed specifically to shield or to protect the confidential informant's identity. That's why name, date of birth, and other identifying information isn't referenced in the documents that are requested. It's a registration number or code that is utilized, and that's in part to ensure that the confidential informant's anonymity remains in place. Also, that's the main thrust of the request, but also that Mr. Rodriguez in this instance is asking for whether the informant in this case was paid, was remunerated or paid any compensation as a result of his cooperation with the police. He's not asking for the specific amount, and he's asking for what happened to the alleged narcotics in this case, which can be understood to mean whether they were field tested and the results of those field tests and so on. It appears that the police in this case did have the ability to field test the narcotics. They certainly did so, or at least they alleged to have done so in the police report that's in the record appendix that describes the events that unfolded when they executed the search warrants. And so this is information that, unlike DM in my recollection, DM asked for the disclosure of the identity of the informant, but in this case the informant's not. It's not clear that the informant's identity would be revealed simply by providing this information.
Thank you. That's all I have.
I just have one question. From the point of view of a former trial court judge, so we have an ADA who is appropriately concerned that the information might reveal the identity of a CI. What happens? Let's assume, for the sake of argument, that we find that Justice Lloyd did not abuse his discretion, allow it to go forward, and the Commonwealth contends that there's at least information contained within the scope of what you asked for, which would risk revealing the CI. How do you proceed, or how do you say we should proceed, or the trial court should proceed?
Well, I think, Chief Justice, in answering your question, the trial court in this instance, the Commonwealth could do a number of things. As the single justice suggested, they can move for a protective order. They could ask for an in-camera hearing. They could redact where appropriate, or they could seek a motion for reconsideration. If all of those things failed and they were still of the opinion that the disclosure obligations would require them to reveal the confidential informant's identity, which I would disagree with in this instance, I suppose they could also elect to no prosecute the case.
Okay, I have no further questions. Any other questions of the justices? And hearing none, that concludes our hearing in the case of Commonwealth versus Rodriguez. Thanks both.
Thank you.
Thank you, Your Honor.